Good evening, Your Honors. May it please the Court, my name is Jacob Capel, representing Blanche Braun. I'd like to reserve 3 minutes for rebuttal, if I may. Your Honors, this case boils down to the simple fact that Blanche Braun's supervisor, Robert Radcliffe, violated Braun's clearly established First Amendment right to speak as a citizen upon matters of public concern, and is therefore not entitled to qualified immunity from Braun's free speech claim, as the district court erroneously concluded. Braun, a receptionist at the Reserve Civil Rights Commission, hereinafter referred to as RCRC, like the Deer Heart Aryan Motherhood Facebook page, which is a white supremacist group. Radcliffe, when he learned about this like, verbally attacked Braun and took away her Facebook access.
Counsel, what was a verbal attack that you're talking about?
Your Honor, Radcliffe called Braun into his office. He insinuated that she was a racist. He told her quite clearly that her job would be in jeopardy if she continued to like this page or join this group. So he made it very clear that he looked very disfavorably on her for joining this group. And we submit that that was basically a threat to her job.
Perhaps justified, perhaps not, but calling that a verbal attack is overselling the case a little bit, isn't it?
I think in this situation, it's not overselling the case, Your Honor, because Radcliffe is her supervisor. So he has a certain amount of authority over her that would make this sort of thing, a verbal attack, rise to that level. He has the authority to fire her. So I think that
anytime a supervisor reprimands a subordinate, that's a verbal attack? Is that your position?
no, Your Honor, that's not my position, but I think in this context, it was a verbal attack because of this specific situation. Braun was exercising her First Amendment rights, and for him to threaten Braun for doing that, Braun interpreted that as more of an attack on her character, as opposed to a normal reprimand for maybe not doing her job up to his standards. So in this context, we submit that it is a verbal attack. It's not just an ordinary reprimand. This is something that rises to a different level. Just as a preliminary matter, my opponent is going to argue that this court lacks jurisdiction to hear this case because the district court's summary judgment ruling was not a final decision. However, this court has jurisdiction over this case and should hear this case for 3 reasons. First, the district court's summary judgment ruling meets the Ninth Circuit test for 1291 finality because Braun dismissed her remaining claims without any attempt to manipulate this court's jurisdiction. 2 factors that the Ninth Circuit focuses on are whether the appellant retained any jurisdiction or stipulated that she could reinstate her remaining claims if her appeal claim was reversed.
Isn't that what happened here? She dismissed without prejudice. That means she can go back and relitigate her other 2 claims if we decide against it, right?
That's correct, Your Honor, but technically the same thing happened in the Ninth Circuit case, James, where the plaintiff dismissed her remaining claims without prejudice, as Braun did here. And the Ninth Circuit heard the case because the plaintiff, as Braun does here, runs the risk that her claims are going to exceed the statute of limitations. So there is some risk that she will not be able to reinstate her claims.
What is the statute of limitations in this case?
I'm sorry, Your Honor, I don't know. The other factor that the Ninth Circuit focuses on is whether the district court expressly approved and ordered the voluntary dismissal. And in this case, the district court did order the dismissal. Although it was without prejudice, the district court had a discretion whether to grant and order Braun's motion, and it expressly did grant and order that motion. It was it was thoroughly finished with her case. And that brings me to the next test, where a number of circuits have followed this test, where the district court's ruling completely dismisses the entire action. The 6th, 8th, 2nd, and 4th circuits have held that this constitutes a 1291 final decision. Here, the district court ruled on one of Braun's claims and expressly dismissed the others. It was aware that it was dismissing her remaining claims. It was aware that it was disposing of Braun's entire action. So here, the case is materially similar to the 2nd, 8th, or the 6th, 8th, 2nd, and 4th circuit test. And finally, this court should hear this case because the danger of denying justice to Braun vastly outweighs the potential for piecemeal review. If Braun cannot like the page and join the group, she will either have to incur crippling daycare costs or run the risk of being fired at her job. We submit that this is a predicament that is completely unfair to Braun, and therefore this court should hear this case and decide this crucial issue. Now moving on to the substantive issues of this appeal. Your Honors, qualified immunity protects government officials from liability so long as they do not violate clearly established constitutional rights. Here, Braun has met her prima facie case for free speech retaliation against Radcliffe because Radcliffe punished her for speaking as a citizen on a matter of public concern. The most crucial factor in the district court's ruling was their finding that a Facebook like does not constitute First Amendment speech. However, this ruling was erroneous for 3 reasons. First, the Fourth Circuit expressly reversed the case that the district court relied on, finding that Facebook likes can constitute First Amendment speech. Second, federal courts hold that communication on social networking sites, including Facebook, constitutes First Amendment speech.
Counsel, is it relevant that the District of Virginia case that the district court relied on was good law, not only when the district court reached its decision, but also when Radcliffe acted?
Your Honor, I think it is somewhat relevant. However, there were other cases decided before that case that would put Radcliffe on sufficient notice that what he was doing was violating Braun's free speech rights.
Are you saying that a manager of a civil rights commission is reading the U.S. reports in the Federal Reporter and getting notice that way?
No, Your Honor, that's correct. I don't think he would be, and I don't think he would, in the same fashion, I don't think he would know of a district court's ruling in Virginia to somehow believe that what he was doing wasn't violating Braun's free speech rights. So the main issue and the main concern that this court should be focused on is whether overall the case law gave Radcliffe a sufficient notice that by verbally attacking someone for exercising their First Amendment free speech rights, he was doing something wrong. And in this case, there were numerous courts that held before Radcliffe acted that communication on social networking sites was First Amendment speech. The Supreme Court in Reno versus American Civil Liberties Union held that a statute that prohibited indecent communications over the internet restricted First Amendment speech. The Third Circuit in Layshock v. Hermitage School District held that a student's MySpace posts, which is a site pretty much the same as Facebook, were First Amendment speech. A Minnesota district court held that Facebook postings were First Amendment speech. Moreover, Braun's like meets the symbolic speech test, which was articulated by the Supreme Court in Spence. Braun's intent was to convey a particularized message, and Facebook users would understand this message. In fact, Radcliffe admitted that by liking something on Facebook, you're actually liking it. Clearly, Braun's like was meant to endorse a white supremacist group. The second prong of Braun's prima facie case is that she was speaking as a private citizen on a matter of public concern. Here, Braun liked the motherhood page on her lunch break, and neither the motherhood nor Facebook had anything to do with her duties at RCRC. Garcetti, the Supreme Court in Garcetti held that a government employee speaks as a citizen when the statement is made outside the duties of her employment. The court also held that the fact that an employee likes the fact that an employee speaks at her job is not dispositive of the issue. Moreover, Braun spoke on a matter of public concern because endorsing a white supremacist group was something a general interest and valued and concern to the public when she liked the page. And racial discrimination, a core belief of the motherhood, is a matter of